When the Law Society of Upper Canada decided to sponsor a one-day workshop on basic problems in evidence, the response was somewhat larger than was anticipated, and the program was therefore subsequently repeated. The workshops took the form of a lecture followed by a panel discussion in each of the morning and afternoon sessions. The panel discussions were, however, a little out of the ordinary. They consisted of a number of short TV scenarios, each of them followed by a panel discussion examining the various evidentiary problems that arose. In the second workshop, the panels were switched around a little so as to give some variety in opposing views. Both sessions were recorded on videotape, and these programs are an edited version of the discussions of the evidentiary problems arising from the simulated courtroom scenarios. I do not think you will find many clear-cut answers to these fairly common problems. What you will find are discussions of some basic but extremely important principles from which solutions are suggested. This program is designed primarily for the legal profession, though we hope that others will be interested and will perhaps gain some insight into the workings of this aspect of the legal system and the way in which the law tries to reconcile conflicting interests. For the lawyers in particular, citations and references will be given for cases and materials mentioned should they wish to make a note of them. There were in total 4 panels, of which 2 each discussed separately half of the fact situations. On the first day, chairing panel number 1 was the Honourable Mr. Justice Edson Haines of the Supreme Court of Ontario. With him appeared Mr. William Poole, QC, practicing in London, Ontario, and a member of the Ontario Law Reform Commission, and Professor Hugh Silverman, QC, a practitioner of many years' standing, and now Professor of Law at the University of Windsor. Chairing panel number 2 was the Honourable Mr. Justice Thomas Zuber of the Supreme Court of Ontario, and with him were Mr. Clay Powell, QC, counsel in the Ministry of the Attorney General of Ontario, and Professor Desmond Morton, QC, who is both a practitioner and a law professor at the University of Toronto. Mr. Justice Zuber also chaired the first panel on the second day's program, and appearing with him on that occasion were Mr. Justice Frank Weatherston of the Supreme Court of Ontario, and again Professor Hugh Silverman. Mr. Justice Haines chaired the last panel, again with Mr. Clay Powell and Professor Morton as the panelists. As a result of the editing, panel discussions do not always appear in the order in which they were presented. The cases dealing with permitting a witness to refresh his memory by referring to notes on the witness stand are not very satisfactory, and the panel now discusses under what circumstances such notes may be used and whether they then become evidence that can be shown to the jury. The point is also made that the Supreme Court case of Aries and Venner and recent statutory amendments may make it easier to get in notes and documents as direct evidence in themselves as business records exception to the hearsay rule.
A civil trial for damages. Counsel for the plaintiff is examining a doctor.
A doctor, I understand that you were in the emergency ward at General Hospital when the plaintiff was brought there by ambulance?
Yes, that's right. As I recall, Mr. Jones was brought in about 2 a.m.
And did you examine him at that time?
Yes, I did. We wanted to determine as quickly as possible what his major problems were so that treatment could begin immediately.
And what were your findings at that time?
Could I refer to my notes?
Certainly.
Well, only if they are his notes.
Well, these notes are compiled by the hospital staff.
Well, then, with respect, Your Honor, I must object to the witness refreshing his memory by using notes which he did not make.
All right. Well, I think the problem is pretty clearly outlined. Question of with what. can a witness refresh his memory? Here we've got something that he didn't prepare himself. Professor Morton, can he use these hospital records to refresh his memory?
Well, my friend Professor Mewett has been fighting for years to try and clarify this area, and he's certainly put me on guard in this area that there are two concepts of evidence involved, the recording of memory and the revival of memory. Now, to deal with the recording, if the doctor didn't remember anything at all, and if the hospital staff had made notes at the time and he had checked them at the time and could remember checking notes, which he could now identify as having checked and could remember that they were accurate, I think he could then use them as a substitute for memory. Now that is a distinction which is not generally acknowledged in practice here in Ontario, in my experience. It is really, in my opinion, what the police officer does when he looks at his memo book. Basically, the police officer can't be expected to remember, nor can he be expected to have a revived memory when he looks at his memo book. So what he's really saying is, I don't remember, but here's a careful record of what I knew at the time, and I'm prepared to vouchsafe its accuracy. I understand from my friend Mewett that under those circumstances, probably the record ought to be put in as evidence itself. That, of course, is not the practice here, and I can just hear the howls if you asked a police officer to put his notebook in as an exhibit. I don't think, with all respect, that many members of the bench would compel a police officer to do that, but I think they ought to be consistent. The other situation is memory revived, which I think Mewett has made vivid to me by talking about tying a knot in your tie. That is, you're trying to remember that you've got to do something, so you try to trigger your memory in some way. Now, if the doctor looked at these notes and said, now it all comes back to me, now I remember, I can swear that I remember it accurately and carefully, I think he could do that. So there are really the two possibilities, one that he's able to say this is an accurate record and substitute it for his memory, or the other possibility is that he could use it to jog his memory.
All right, thank you. Mr. Powell, we've heard several times, I think in the course of the day, that there are these two conflicting, or this theory, I think it's the Wigmore theory, that there's two ways in which you can do this. You can actually refresh a memory and bring things back, and under that heading you can use almost anything, the daily newspaper or whatever, to trigger off your memory. Or you can put in a document showing your past recorded memory, and there you're squeezed down to things that you've made yourself, or at least under your approbation, and different rules apply. Now that's Wigmore, but what do you think, Mr. Powell? Are we doing that in Ontario? Do the Ontario cases reflect that distinction?
See, I don't know that they do in criminal matters, and my knowledge of civil matters is so small I can't even buy a new house, and I have to hire a lawyer to do it. So I really don't know anything about the civil practice. I don't think that the criminal practice, though, draws a distinction really of that nature. To me, the interesting thing here is, of course, that the notes being made by the staff, by a hospital staff, I could see this, say, arising in a criminal case, let's suppose, as to the condition a person was in when they were brought in. It seems to me that under the doctrine in the Supreme Court of Canada judgment in Aries and Venner, that those notes are admissible as prima facie evidence of what they contain. And that, to me, is the really crunch issue that arises out of this matter. I know after the Myers case in England, then they amended the Evidence Act in England, and then we did the Ontario Evidence Act in relation to business records, and then just as we were getting ready for a nice good case to come along in a criminal matter, along came Aries and Venner, which is a very wide judgment in the Supreme Court of Canada. But it seems to me that those notes then go in for what they contain. So it's a step more here than just him looking at them, because he may look at them, but it seems to me then if they're marked as an exhibit, then they're in any event, aren't they? And could be referred to for what they contain, possibly. I don't know.
Thank you. Just for what it's worth, and subject to what Professor Mewett said this morning, it seems to me, at least, that this distinction between refreshing one's memory and using past memory recorded has been lost in this country and in the cases that are decided here, that the two doctrines seem to have somehow or other been squeezed together, and that despite the fact that you're only trying to refresh your memory, our cases seem to say that you're still obliged to only use documents that you have prepared yourself or under your direction or with your approbation, and we've squeezed the doctrine down to only using the documents that would be under the second Wigmore rule of past recollection recorded, so that we've taken the narrow end of the Wigmore view and say that those are the only documents that will allow you to use either to refresh your memory or to demonstrate its past recording. Now, I put forward to you the difficulty that one finds oneself in when you get a situation like this. What happens then when you have a document which under the business records legislation or under Ares and Venner becomes itself admissible, even though you haven't prepared it and haven't signed it and didn't do it contemporaneously and all that sort of thing. You're into sort of a silly situation where you then could be said not to be able to look at it to refresh your memory.
Let me take this, and this I find intensely interesting. Counsel for the defense in many cases will walk up and say, let me see that history, you see. Crown doesn't object. He takes a look at it. Now, if, I'm going to put two cases to you, if it isn't helpful to him at all, he usually gets it back into the doctor's hands and gets down quite quickly, doesn't he?
Yes,
but if like the policeman's notebook.
Like the policeman's notebook.
He looks,
yeah.
hands it back. Yeah.
But if he finds something in there that helps him, and the doctor says, no, that's not so, and they get into a dialogue about it. Now I ask you this question. Should that not be filed for the jury to examine to see whether or not it supports what the doctor says?
Absolutely. Yes.
You agree?
I agree with that, no question. But if they're going to get in a dogfight about the contents of the document or the book, whatever.
That's right. In other words, cross-examination might make that document evidentiary, which otherwise it may not.
That's right. The defense counsel has to be careful, I would think, at that point, as to the tactic he's going to adopt with respect to that.